afternoon, my lords. In my submission, my learned friend has effectively 4 hurdles he has to get over in turn in order to succeed on this part of the appeal, as follows. Firstly, that the claim has a clear and unambiguous exclusionary meaning. Secondly, that exclusionary meaning relates to both isolation, by which I mean the call processor needs to be entirely outside of the call centre rather than being integrated within it or distributed partly within and partly without. And secondly, routing. It has to exclude routing via some aspect of the call centre. Thirdly, you must establish that that exclusionary meaning must be applied regardless of all the contraindications in the specification. And finally, he needs to show on that meaning that the subject matter hence claimed is inventive over the cited out Van Valkenburg and Schaffer. So let's look at it along those 4 lines. First of all, that the claim has a clear and unambiguous exclusionary meaning. We've heard my learned friend say that integer 9 does a lot of heavy lifting and excludes the routing arrangements. We haven't heard at all how he gets around the implementation, the distributed implementation point. Of course, this is a method claim, although there's an apparatus chunk within it. But when we look at the spec, we'll see that there's nothing in the claim that excludes the distributed implementation. I'm not intending to read through the claim and tell you how to read the English language. I'm not sure that's enormously helpful. I think my Lord Justice Nugee already has the point on 9F and how merely by defining 2 endpoints, or beginning point and an end point, one is saying nothing about the route taken in between the 2 as a matter of ordinary language. So let's talk about construing the patent. This is quite a long section, so I'm going to break it down. I'm going to talk first of all as to the process of construction of a patent document. I'm going to talk about and give you some guidance into how the description actually helps. Then I'm going to go through the patent, which I will be doing in some detail. And then I'm going to do 3 things. I'm going to first of all say what I have to say about it, then what the judge does, and then go through what the appellant has said and tell you why he's wrong. So, the process of construction, there's basically 4 steps.
Just before you proceed,
yes.
Davis, can you just remind me of what's been agreed about timing for this afternoon?
I was going to sit down at 3 minutes to 4 precisely.
Very good.
And give my learned friend 15 minutes plus an extra 3 bonus minutes to speak.
I will hold you to that. Thank you.
By that clock. The process of construction, there's basically 4 steps. Firstly, identify the skilled addressee, and that can be a team. The judge does that at some length, and there's no quibble with that. Effectively, it's the payment process person and the telephony engineer. It's a team of the 2. Secondly, set out the relevant background, common general knowledge. And again, that's done extensively in the judgment. And for today's purposes, there's no dispute on that. Thirdly, they read and understand the patent and what it's doing as a matter of technology. And lastly, they then sit down and construe the claim in the context of all of that. So my next topic, how does the description help? Well, the description is supposed to do 2 things under the statute. And this is partly in response to a question raised this morning. We don't have the statute in the authorities bundle. I don't know whether you have Terrell in front of you, but the relevant section is section 14. So I'll read it to you. There's 2 things it has to do. Under section 14.3 of the Act, the specification of an application shall disclose the invention in a manner which is clear enough and complete enough for the invention to be performed by a person skilled in the art. So that's what the description has to do. The other aspect of the statute that gives guidance as to what the description has to do comes from section 14 subsection 5. Now that describes actually what the claims have to do, and they have to do 4 things. A, define the matter for which the applicant seeks protection. B, be clear and concise. C, be supported by the description. And D, relate to one invention or group of inventions having a single inventive concept. So we see there C is giving a function also to the description that it has to support the claims. So that's the governing statute. Whilst it is the case that patents are amended so as to narrow them, broaden them, and potentially embodiments move in and out of the claim, in my submission, the starting point should always be that if one can, without doing violence to the language, construe the claim such that something described within the description as an embodiment falls within it, then that is what one should do. And my authority for that is the judgment of, I think it's Sir Christopher Floyd, because I think he'd retired at that point, in the Philip Morris case, which is in tab 5 of the bundle. And if I can ask you to turn to page 189 of the bundle, para 43, the 5 grounds of appeal are set out. And at 44, the judge says it's convenient to deal with grounds 1, 2, and 3 together. Now, what happened here is there was some claim language, and it had 2 characteristics. The first bit was it required 1 or more of electrically conductive tracks. And the second point, it required that they, leave aside what they means, is a plurality of portions, each portion being separately connected to the power supply. Now the question was whether each one of the tracks had to exhibit that characteristic, or the 1 or more tracks taken together could exhibit that characteristic. And the point put by the respondent, I think, was the claim construction taken by the judge was that collectively the 1 or more had to exhibit that characteristic. And he did that because that's what happened in one of the embodiments. And the criticism made of him by the unsuccessful appellant was that the judge took too much notice of the embodiment and didn't really concentrate enough on the language of the claim. And with that context, perhaps I can then ask you to read what Sir Christopher says at paragraph 46 of the judgment. So, effectively, my submission is this. Whilst it is possible for an embodiment, whilst it is conceivable that an embodiment is outside the claim, unless it is really doing violence to the language of the claim, the working assumption is that it's inside. That's where we say figure 14 gets us on the language there. So that's what the Court of Appeal had to say about embodiments and descriptions. Now, my Lord Justice Arnold brought up earlier the issue that the practice in the European Patent Office, bringing things into conformity with the specification, is currently evolving, let's put it that way, and I think it's been referred to the enlarged board. However, the practice before the UK IPO, which is what the Patent Office calls itself these days, is slightly different. And this is a GB patent, not a European patent, so therefore was prosecuted before the UK IPO. The UK IPO publishes something called the Manual of Patent Practice, or MOP as it's known. And that is what tells patent attorneys the way they ought to be doing things. And that is to be found at tab 8 of the authorities bundle, page 227. And perhaps I can just ask you to read that to yourselves, because that's the Patent Office practice on this.
Who is this addressed to?
This is the Manual of Patent Practice. It's on the IPO website. It's regularly updated, but it's addressed to everyone.
In the first instance, it's addressed to the office's own examiners.
As to what to do during prosecution and
So
how
when it's
things should be adjusted.
Objections, it's saying to the examiner.
The Patent Office examiner, yes, yes.
You should object.
Yes.
Yes. I see.
Yes.
Thank you.
And is there authority which says that the courts can or should refer to this as an aid to construction?
I think the answer to that is probably yes and no. There are cases, and I'm trying to think what they are, that says that the whilst the specification is to be read by a person skilled in the art, the person skilled in the art is deemed to understand aspects of patent drafting practice. Just can't remember exactly what the cases are.
That was one of the Virgin cases.
Yeah. Yes, I think that's right. I think it might have been Lord Justice
What later became Virgin and Zodiac was one of the stages in that litigation.
Yes. Yeah. That's really where I get to on patent drafting practice, and just to give, in particular, my lords here, some help with how does one go about actually reading a specification of a patent. So that's repetitive, I'll move on from that one. I will talk
That
then...
doesn't help
Yeah.
with one of the questions that I asked Mr. Silverleaf, which is whether the application is admissible in construing the patent. That's a separate point.
Well, I was hoping you wouldn't ask me that, because my answer to that is, I
said it was Court of Appeal Authority. Thinking about it, I'm not sure it is. The case I had in mind was Milliken, but that was Mr. Justice Jacobs sitting at first instance. And he did exactly that. Yeah, Walkoff Max and Milliken. Yeah. He construed the granted patent by reference to the application, but I don't think that's had previous.
I don't think it is correct to construe a patent by reference to the application and what happened. What one is the specification of the granted patent should stand or fall as a technical document on its own. Certainly, the Supreme Court in Actavis, which is in the bundle, when they look at the three questions, but the other aspect they consider is something called file-wrapper estoppel. To what extent can you look behind for construction with what happened on prosecution? And the Supreme Court, they say it can be done in very, very confined circumstances, but they're not these.
There's a problem because a patent, unlike a contract, is not addressed to particular parties, it's addressed to the world.
Indeed.
So everybody ought to be able to pick it up and read it and understand it. So
It's, as Lord Diplock said, it's a unilateral statement in the language of the patentee's own choosing.
And presumably the world would not usually have access to the detailed toing and froing of the prosecution.
It's very easy to find for the European Patent Office, because it's all online, the UK is gradually moving online, but it's not as extensive or reliable. But the looking behind the patent spec itself to look at aspects of the file is possible, but heavily confined to precise circumstances.
Activist says in theory you
In
can
actual-
do it, but in practice you can't.
In theory, you can do it. In practice, someone in this room has tried it twice and gone down in flames both times. And it's been a lot better case than this. And the other point to make on that is what I'm looking there at is what the patentee is telling the patent office. Of course, there are letters, but my learned friend hasn't put them before the court. I don't actually know if what was said in prosecution was put before the court at first instance. But it really doesn't help either of us, to put it in a nutshell.
Anyway, you're not relying on the application.
I'm not relying on the application. The purpose...
Are you inviting us to ignore anything that Mr. Silverleaf, which drew on a contrast between the language of the application?
Well, it's just as bad for him as it is good for him. Because one of the big differences that my patent attorney sitting behind me spotted is figure 12, which was said in the application to be an embodiment of the invention. They then deleted the word invention and just called it an embodiment. So it's just as bad for him as it's good for him. It doesn't take either of us really anywhere. And I'm not. My firm submission would be that I do not believe there's decided law upon this, but the indications from the Supreme Court as to looking behind the granted patent specification are very clear that it should be done only in very, very limited circumstances, and only if it unequivocally points one way rather than the other.
So you invite us to read the grant as
Yes.
a standalone document,
Yes,
available to the world.
yes. Yeah.
Thank you.
Okay, so the drafting of a patent specification. There's 4 parts in a patent spec. One starts off with the introduction or the background. You proceed on to what are known as consistory clauses, and they mirror the claim. Then there's the description of the preferred embodiments, and then there are the claims. And each part really has its function. The consistory clauses, insofar as anyone knows really why they're there, it's probably to comply with 14.5c, that it then gives support for the claims, because you can never say a claim isn't supported if it's entirely recited within the patent spec. The other reason patent attorneys put them in is because you pay claims fees on claims and you don't on consistory clauses. So they're a cheap way to get lots of claims in before the USPTO and the EPO, but not the UK. But that's an aside. There's then the description of the preferred embodiment, and that has to set out so that you can put the invention into effect. This specification generally follows convention with 2 qualifications, I would say. Firstly, after the consistory clauses,
What does consistory mean?
they...
The expression comes from the sort of language says the invention consists of, and then you find something recited which matches what's in the claim.
I'm afraid I didn't know that, so I'm obliged for that explanation. But I say the point...
That style of drafting is no longer used, I don't think.
It's not generally used, but consistory clauses say they tend to stay in, firstly because you can never say a claim isn't supported if its entire teaching is there. And secondly, I say one of the reasons to become more popular is the EPO have now introduced excess claim fees over and above 10 claims. So if you put in loads of consistory clauses, you can pick and choose which ones you could later pay claims fees on.
You're right, it's a mad one.
That's how it's done. Right, this specification generally follows convention. 2 qualifications. Firstly, what follows the consistory clauses, and what my Lord Justice Arnold described as pseudo-consistory clauses, is just a load of sort of consistory clauses that say you could do this, you could do that, you could do the other. I've described this in my note as the quagmire. because one can easily get stuck in it and lose the will to live.
It's got lots of optionals.
Lots and lots of options.
At least one.
But the difficulty with relying on what's in that part of the spec is there's very, very little teaching as to how you can mix and match them. Which ones might be inside the claimants, which ones might be inside, which ones you can put together, which ones are inconsistent and you can't put together. One really only gets that flavour when one moves on to the main part of the specification, the specific description. The second slight parting with convention is that this pattern ends with a sort of overview that seems to be a recap, and that's quite unusual.
Is it usual for patents to single out what they say the inventive concept is?
That's what Claim 1 is supposed to be for.
Yes.
Would be my answer to that. And that would then be copied back as to being an aspect of the invention consists of, and then they'll cut and paste Claim 1. Sometimes you'll see it, the present invention provides. The present invention provides a method as set out in Claim 9, or something like that. So sometimes it's literally just a cross-referring. Without wanting to be rude, patent attorneys want to keep their options open as long as possible. Which is why we have claims to define subject matter, to pin people down. Right, let's look at this patent. Now, where's my... That is in the supplemental bundle, tab 1. Now, okay, let me give you a little roadmap of the patent, which I think is going to help. How I read it is this. The introduction starts at page 1, line 1, unsurprisingly, and goes on until halfway down page 2, where the consistory clauses start. So the introduction, page 1, line 1 to page 2, lines 25. We then have consistory clauses, which falls into 2 parts. The first is true consistory clauses, which are from page 2, line 26, through to page 3, line 19, because I'm counting the Claim 60 consistory clause, and then sort of descends into the quagmire of preferred features, which is between page 3, line 20 to page 17, line 8. We then have on page 17 the description. The description is going to start, and it's going to take us through the 19 figures. Now, trying to divide up the description itself, one starts off with figure 1, which is the prior art. Figures 2, 3A and 3B give us the basic structure of the system from a hardware perspective. And then figures 4 all the way through to 10 are going to describe the process and how it works, the 2 different modes. We're then going to go into various embodiments, alternative arrangements. So basically, the basic description, leave figure 1 because it's prior art to one side, is figure 2 through to figure 10. That gives you the core embodiment that we say is what is being claimed. Then figure 11 gives you a first alternative, which we'll come to. Figure 12 gives you a yet different alternative. And figure 13 gives you a yet further alternative, that's the hosted gateway. And then figures 14A, B, C, together with 15, give you various other alternative ways of doing it with different integration options. We then get figures 15, 16, 17, which seem to describe various other options that aren't relevant to present purposes. And then we get figure 19, which should actually be figure 18, that tells you the same thing all over again. Sorry if I'm going too fast, but I will slow down. So that is a sort of bird's eye view of how the specification is written. So then going through those portions, starting off my note, section 1, the introduction, and effectively what I want to get out of this is 3 mentions of generally this is what it's about, but it's about keeping your sensitive information away from the agent. It's not one way of keeping it away from the agent may be to keep it away from the call centre, because that's where the agent's sitting. But what it's really all about is keeping the sensitive information away from the agent. And it says that 3 times, I think. One passage starting at line 33, a second passage on page 2 at line 13, and a third passage on page 2 at line 90.
What about page 1, line 3, line 4?
Yeah, that's my learned friend's best case, yes. I think. That it is without having to disclose sensitive information to the call centre. That is, to some extent, slightly ambiguous, because what it goes on, that is the most general exposition of the invention. And whilst that could be read in the way my learned friend wants it read, what becomes clear from the remainder of the specification is what it's really interested in is keeping it away from the call centre operative.
Well, I may have misunderstood it, but I think Mr. Silverleaf said that one reason why you might want to keep it away from the call centre as such, and not just the operative, is because of compliance requirements.
Yeah, we will come to that. It is certainly the case that the figure 12 embodiment, or I think the figure 13 embodiment, whichever one he wants, exists and has that additional benefit that it keeps it away from the call centre operative by keeping it away from the call centre. And that way it will also assist in PCI DSS compliance. That is a preferred, a narrower solution, and claim 9 is much broader than that. That's my submission, and we'll see that when we look at the options. Having been very insulting about the section I've called the quagmire, I'm going to avoid stepping into it for the moment, other than to mark up, and it's sections we've looked at, that it does describe 2 routing embodiments for payment information, one directly to the external entity and one via the call centre. But it's better put when one actually gets to the main part of the specification itself. So let's do that. So I'll pick it up at the bottom of page 17 of the patent. Line 41, which starts figure 1. So this introduces the prior art. And we go, let's turn the page immediately and go to figure 2. And figure 2 is the a telephone call processing system, so it's what the patent's all about. And one can look at the diagram at page, I think it's 4 of the bundle. But what's important here is when one looks at immediately how it is introduced, at line 16 of page 18 of the patent. It is arranged such that the agent has no means by which to circumvent the call processor and interact with the caller directly. And it makes clear, as will be described below, call processor 40 acts to modify characteristics and route data to the entity such that sensitive information from the caller is barred from reaching the agent while allowing the agent to assist the caller. So the initial introduction makes clear that firstly, it can be implemented at the call centre. Admittedly, it's in a separate box, so that may or may not help me. But what it's saying is important about the patent, right from the kickoff, is it's about splitting the information, modifying the data parts of it, so it doesn't go to the agent. Further down the page, at 36, it introduces figure 3A. And then on the following page, page 19, we talk about the two modes, normal and safe. Where are we? Yeah. So line 8 of the patent now, it's told you sort of generally what it's going to do, and it's now going to describe how you might want to embody it in hardware. And this is quite important. Line A, in some embodiments, the components of the call centre are modularised. In the embodiment shown in figure 3B, for example, the call processor essentially comprises three main modules: the telephony card, the telephony processing module, and the data processing module. So let's just turn to those.
Let me just correct one thing. You said, when reading it, you mistakenly said call centre in line 8. You meant call processor.
I did mean call processor, so I apologise for that.
That's all right.
I'm trying to take things too quickly, but there we are. So just turning back to figure 3B, which is page 6 of the bundle. We see there an embodiment of the call processor. So there's the single box 40, that's the call processor. Top left, we've got the first telephone interface. Top right, we've got the second telephone interface. And right at the bottom, we've got the data interface. The telephony card 50 is what is doing between the first two telephone interfaces, is what is doing the stripping out of the data signals, and it then sort of passes them down through the control interface all the way down to the data processing module. And the data processing module is what is doing the assembly of the request, the generating a request based on the transaction information signals feature E of the claim. That is being done in the data processing module, which then comes out the data interface at the bottom.
What is the purpose of a telephony processing?
That does other aspects of control, but I'm not sure it does anything relevant to the claim. It might do some encryption or whatever. It's part of the preferred embodiment, but it's the top module, telephony card 50, that's doing the dividing and blocking. Splitting. The bottom module, the data processing, is the one that's doing the generating the request, transmitting it, receiving it, and processing it. And the telephony module in the middle is can be doing a certain amount of encryption. Because what we'll find in a moment is the telephony module and the data processing module can be in different places. So you might need to encrypt the data to get it from one to the other. And we get that, I hope, at back to page 19, in some embodiments, components are modularized. So in the embodiment in figure 3b, the call processor has these three main modules. It then describes the telephony card, then describes the telephony processing module, and then it describes the DPM, the data processing module, from line 37. But what's important is what we're told on page 20, starting off at line 4. In the implementation described with reference to figure 3b, the telephony card 50, TPM 52, DPM 54 are all implemented in a single unit. For example, they can be in a server, and the TPM and DPM can run on that server, thereby providing a one-box solution. This implementation is particularly beneficial for applications for which a smaller platform is required. Other implementations, which are particularly well suited to requiring larger scale platforms, are described in more detail later with reference to figures 17 and 18. And then it goes on. Where the call processor is provided at agent premises, such as in the call center, the TPM 52, DPM 54, and or the telephony card may be provided as part of an application server at the premises. The application server may be configured to handle other transaction-related applications relating to, for example, purchase management, etc., etc. So what we get out of that is that this system, in small-scale implementations, you can put it in a single box. But in larger scale, you can spread it over various boxes. And your DPM box, which is doing the stuff at the end of the claim, integers E, F, G, and H, can be implemented on the application server of the call center itself. Where I'm going with this is trying to say it's not all about excluding figure 14. The fact that this is not all about just a small isolated example runs through the entire DNA of the patent. That is what it's all about. All right, let's move on. We then find at page 20 the foreshadowing of the two modes, the normal mode and the safe mode. And then at figure 6, we're going to be told all about the process that is to be conducted by this call processor module. So if we turn back to figure 6, we see this. I'm not sure what the name of, there must be a label for this type of diagram. But what this diagram shows is the flow of the process and what information is moving from where to somewhere else. So we start off with step 1, that is going to be initiate the call. So the caller is sending out the call to the call processor. At step 4, it's being forwarded to the switch. And at step 5, it's being forwarded to the agent. So we now have 7, a voice call between caller and agent. Then at step 10, the agent tells the caller, I want some money out of you, please, payment request. And at 11, the agent communicates with the call processor to say, I'm about to request some DTMF details, and here's some payment info. Squirrel that last bit away, because it will come back to haunt us a bit later on. We then move to the safe mode, as shown by the sort of dotted line. So that's the setup procedure in figure 6. And we need to then turn back to see how that is described. So that is page 21. We're going through the various steps now in the text and we've got initiate call, generate URN, and we've talked about steps, the initiate call steps, step 7, the voice call, step 10, the payment request, and step 11, the DTMF request. And so the call center agent has asked for the details, and that is explained on page 22. And then at the bottom of the page, we're told those skilled in the art will be able to contemplate a number of alternative scenarios requiring acquisition, processing, and forwarding of the payment information to enable maximum compatibility with existing systems. For example, turn the page, we then have 3 bullet points, the third of which I don't really understand, but the first 2 of which are important. The first is that the call processor gets the number, all or part of the card number from the caller, and passes it on, this information, to the agent's system or database A directly, bypassing the agent. The remainder can then be collected. Or, so that's the sort of figure 14 embodiment we're going to come to, if I can put it like that. Or at bullet 2, the call processor is passed the amount to collect and the card type by the agent application, and then all those details can go to the bank, and that's the sort of figure 12, figure 13 embodiment. So already within the description of the general flow, the 2 routing scenarios are presented as alternatives. And that's then emphasized at line 16, exemplary embodiments which we've looked at this before this morning, exemplary embodiments which card dealers pass to the agent system or database without being divulged to the agent are described later with reference in particular to figures 14 and 15. And then other exemplary embodiments, sorry, I've added the word other, in which sensitive information such as card details pass to the call processor for verification to third-party entity without being sent to the agent or agent system are described in more detail with reference in particular to figure 12. So the main exemplary description contemplates both. I'm going to skip that. And actually we see that in the italicized section at line 24, which I accept perhaps can be read both ways. Once the call processor 40 enters DTF, enters safe mode, DTMF tones from the caller are blocked from the call processor and prevented from reaching the agent 20 or even the call center switch. Normal voice communication, however, proceeds uninterrupted. So as I read that, we're still looking at these 2 different options, 2 different ways of doing it. I'm not going to look at the rest of the figure 6 process now. I may do so tomorrow. So I'm going to turn to page 27. And at page 27, we're line 11, we're talking about, the patent is talking about figure 10. Figure 10 shows the call disconnection or termination procedure. So that is the end of that part of the description because it's the termination procedure. So this part of the description, the main exemplary embodiment, stops at page 27, line 16. That's the main chunk of description, 2 options taught. What the description is now going to do is say, here are some alternatives, and some of these alternatives have some good things and some have some bad things, and I'm going to tell you all about them. So the first of these is figure 11, and the figure 11 is the alternative arrangement where the call processor is outside of the call center and says that could be good because the call processor is kept physically separate for reasons of security. So that's a good, that can be a good alternative. Figure 12 talks about a different embodiment which has this additional verification stage, and it refers back. And it says that can be used, that can be good, because the credit card companies like it. And that's the figure 12 embodiment. And then it goes on and says at line 33, in the embodiment shown and described with reference to figures 11 and 12, the call processor effectively acts as a hosted payment gateway. Now, what I read that as saying is, figure 11 says you can be outside the call center. Figure 12 says it can also do verification. Figure 13, which is going to come to, the hosted payment gateway, if you are both outside and doing verification, you're effectively acting as a hosted payment gateway. But it's merely one preferred embodiment. Now, one of the advantages, and I think this is where DSS comes in, yes, it is where DSS comes in, so I'll answer your question, is by doing it the hosted payment gateway way, you get the additional advantage, potentially, of PCI DSS compliance. But in order to do that, you've got to follow the instructions at the bottom of page 27. And in that hosted module, the payment card data needs to be collected from the caller using DTMF as described previously, and call center 25 associated transaction data, merchant ID, payment reference, and transaction value would be sent from the call center 25. So what's happening is this: in order for it to be a hosted payment gateway, it needs more than just what the user is going to tell it. With only that information, it can't assemble the payment request. It needs more. For example, how much, the requirements for. In the hosted example, it gets that more by the call center sending it to the second telephone interface. You then do the assembly process, and that disappears off to the external entity. Now, what's my point here when we get to the claim? Where am I going to here? If this was only about something akin to a hosted payment gateway, the claim does not have all the technical features needing to function as such. Because for a payment request, what is needed is information from the call center. And that only comes two ways. One is the call center sends it to the hosted payment gateway via the second telephone interface. That's what you're being told here. The other one is you don't have a hosted payment gateway. The payment request goes to the call center. The call center can then add that stuff and send it on. And because the claim doesn't specify that, it covers both. It allows both. And we see that, I'm not making it up as I go along, we see that in figure 13, this idea of data moving to the hosted payment gateway of figure 13. Because we see in figure 13, step 1 is merchant ID. So we've got the call center on the right-hand side and the customer on the top left. And the call center is sending the merchant ID, the reference number and the payment value to the call processor. That the other information, the PAN, the DOE and the CVC is coming from the user, and the and the call processor uses both of those, the payment request.
Your credit card number, is it?
Sorry?
PAN is the credit card number.
The PAN is the credit card number, yes.
DOE is date of expiry.
Yes. You're ahead of me. Yes. My point is this. The DSS compliance comes not from just the features within Claim 9. It comes from the feature of the assembly of an entire request at the call processor And that requires information both from the user, which is in the claim, and information from the call centre, which isn't, which is why the claim is not that narrow, because it doesn't have all the technical features.
So in this figure 13 embodiment, call processor does send the verification request direct to the third entity.
One of the things we'll come to right at the end of tomorrow, this is part, and my learned junior said, don't go there, Rich, but I'm going to anyway. The problem one has is that what the patent teaches is two sorts of requests. A verification request that the call processor can send on to the external entity without more, and a payment request which it does need more. During prosecution, what happened is they broadened from those two specific requests with two specific contexts to any request, whilst leaving the context behind. That's the added matter point to look at tomorrow.
Yes.
That's sort of the difficulty. But what my learned friend wants you to do, and he's probably right about this, is well, you should really be trying to construe a claim not to add matter. The difficulty he has is it adds matter whichever way you slice it, but it certainly adds matter on his new interpretation. Have I confused everybody?
I'm dubious about that proposition because, I mean, I think this goes back to the point you were making before. It's at least highly arguable that precisely one of the reasons why you don't construe the specification by reference to the application is because, precisely for that reason, because the added matter objection depends upon the comparison of the granted specification with the application as filed. So if you are construing the granted specification by reference to the application, you're inherently short-circuiting an objection which the statute says you shall not.
All right. You're right. My learned junior was right. I shouldn't have gone there. I apologise. I will move on. But my point, my better point, still stands, and the answer to a lot of the way it was put, and the answer to my Lord Justice Singh's question is this all about PCI DSS compliance? Answer, the figure 13 embodiment probably is, but the claim is not so limited.
Is there somewhere where in the specification it talks about PCI DSS? And says
This exact bit.
This is another particular bonus.
It's the top of page 29. PCI compliant environment.
I also, sorry, page 27 of the specification, hosted payment gateway, line 35-36, is talking about also about PCI DSS compliance.
Yeah.
So that is a reference to particular embodiments. This is your point.
That is a reference to particular embodiments, yes.
So what you're saying is, here are all the things you can do. If you do this one and that one, then you get the benefit of it being PCI compliant.
Yes.
But you're saying that doesn't mean that's what it's all about.
It doesn't mean what it's all about, because the claim is not so limited. Indeed, the judge found as a fact the claim was not limited to payment processing at all. It had more general application. And that's a second and much simpler reason as to why the Claim 9 invention isn't limited to PCI DSS compliance.
What sort of transaction data could you have that wasn't financial, didn't come within the PCC?
PCI. I'm told paragraphs 105 and 106 of the judgment.
Yes, I did read them, but I'm afraid I don't remember.
Can I come back to that?
Yes.
Yeah. Because we're about to get to the exciting bit of the spec, the description of figure 14, A, B, C. And what I'm trying to get over is the the specification is not an unholy mess if one approaches it with a map. What it has done is it's given a core invention, which it's described the process of figure 6, and that goes up until page 27, line 16, and then it's introducing the embodiments, the alternatives, one of which may be PCI compliant, and the others, which we're about to look at, is figures 14A, B, and C. And those are yet further ways of implementing the invention, as described on page 29, line 8. Figures 14A to 14C illustrate different options for simple integration of the call processor into existing systems for acquiring payment information and or for handling transactions. Let's just look
at... back to the question you were struggling with a moment ago.
Oh.
So the example is given in 105 of address, date of birth and national insurance number. So an example of that would be filing an online tax return, for example.
Maybe, yes.
So where you're not actually paying anything at all at that
Yes.
stage, but nevertheless you need the information to be secure.
Yes, you need the information to be secure, but the my learned friend may be right in that if this was to a hosted payment gateway, and if this was only about a process of processing payment information, the skilled addressee at the time might read it with, well, what this is trying to do, and all this is trying to do, is achieve PCI DSS compliance. But because they've chosen to be broader, it's broader than that.
I'll be corrected if I'm wrong, but I think the first reference to PCI DSS is on page 27.
I think that's right.
Which would be pretty astonishing if that was what it was all about.
Depends how well drafted a specification is.
Well, yes.
But yes. Right, figure 14, the figure 14s. Figure 14A, as I understand it, one has, and just turning to page 14 of the bundle, the call processor is doing the splitting of data and voice. The voice goes to the agent, box 20, and the data goes to the application server, box 21, within the call center for onward transmission to the exchange. I'm going to skip 14B because we haven't really talked about it. It doesn't necessarily take us much further. But I do want to address 14C and the way I understand it works. In figure 14C, the call processor splits voice and data. And what one sees is that the voice goes to the outer box of the agent, but the data goes to an internal box within the agent, 20 prime. So they're not actually going to precisely the same place before it goes on to the application server. And what's happening here is this. The agent's PC is running some form of secure, we'll call it that, software. And even though the voice is going to the agent, the data is going straight in to the application on their computer. And this could be advantageous because the data is going straight through to their application, it can't be recorded, which remember is one of the vices they're looking at. Also, another thing that could happen is when the data goes straight through, it could be sort of masked, by little blobs, like one sometimes gets on a password. And what the agent can then do is cut and paste the numbers without being able to see them and put them in
to the lines 24 to 26.
That's exactly what you're told in the specification it's all about. But more than that, the specification actually makes my learned friend's point for him. And he says, this is not a very good way of implementing the invention, but you could do it this way. It's still doing the splitting, and it gets better security, but not brilliant security. And that's exactly the point made in the patent. It's now worth turning to the patent and just reading, perhaps to oneself, page 30 from line 5, those 2 paragraphs. So, my point is this. My learned friend has said, well, figure 14 can't be in because it doesn't achieve the objective. The answer to that is it does achieve the objective in that it has the patented method of the splitting. It in part stops the agent seeing it, and in some ways of implementing it entirely sees that. But not only that, the spec itself tells you that we do appreciate this isn't our best way of doing it, but it's a way you could do it because it's still got the splitting of the 2. So that's why figure 14C is bang within the claim. All right, that's enough on the figure 14 embodiments. There's then a number of other variations one could look at, but I don't intend to. And they are described yeah, I'm gonna leave that for the moment. They are described over the next few pages. And really I want to skip them until we get to the scaling aspect, which is described on page 35 at line 30, from line 31 onwards. And where I'm going to really on the scaling is whether you put the system in one box or more than one box, and to what extent you use the call center existing integration is a choice of implementation. But actually it's mostly on the basis of whether it's small scale or large scale. And for larger scale applications, you'll want to split it. So we have that page 35, line 32, the modularization of the call processor described with reference to figure 3b, so that's putting bits in different places. And in particular, the use of appropriate control and data interfaces is particularly beneficial for providing a scalable and robust solution. So make system, yes.
I just want to make sure the transcript is always...
I do beg your pardon. I don't mean to
I understand.
I'm slightly dyslexic and my brain doesn't always see what's written on the paper. It sees what it wants to see.
Understand.
So that's what I get on to make good sort of what I was saying earlier on 3b, the fact that one can modularize and one may want to distribute the solution. So it may be that the routing of the information via the call center becomes a bit of a red herring because it's already in the call center infrastructure before it gets to the data interface because of the way the implementer has decided to implement as to whether it's large scale or small scale. Sorry, I haven't put that very well. Right. Finally, the distributed solution starts, we looked at the start of it on page 35. I just want to look at the end of the description of the distributed solution at page 38, line 18. which again makes clear that in circumstances the processor will pass, the converted data are dispatched to the call center for internal processing without disclosure to the agent. So again, to show that a distributed solution is an implementational detail, not necessarily a routing detail. The specification then proceeds to give its overview in the next just over a page, starting at page 38, line 24. And again, the overview effectively picks out the key bits. In particular, we say the core teaching, the key teaching of the invention starts perhaps at line 33 of page 38. And in particular,
Just
the
before we
last
get
line.
there,
Yeah.
although he didn't say so in terms, I understood Mr. Silverleaf to read the first sentence as if the brackets before or and in line 25 and after centre in line 26 were not there. Do you agree with that reading? Certainly it's not at all easy to understand what those brackets are supposed to be doing.
I don't see those brackets doing, I don't think those brackets should be there. Right. My submission on this...
That was how Mr. Silverleaf read it.
Well, my submission is perhaps this. It was put to me once that words are our servants, not our masters. It's also been put to, I think, both of us today that this might not be the best drafted patent ever. And meticulous analysis as to positioning of brackets and the like as an aid to construction is not particularly helpful.
Well, that's undoubtedly correct, but one does have to try and understand what the sentence is saying, and I find the brackets an obstacle to that. So, speaking purely for myself, I find it easier to try and understand the sentence, imagining that they're not there.
I would endorse that. Because what we've been taught is we've been told about a call processor which could be used as a hosted voice payment gateway. We've also been told about one that could be used at customer premises, and we've told about one that could be embodied on customer provided equipment out of the call center. So I would see those as three options. What I've tried to do, and I accept it's been a whirlwind tour through the patent, is try and explain the core technology and what it's describing as technical solutions, which is tolerably well described, rather than looking at the...
So you were going on to line 33 before I interrupted.
I was going on to line 33 because I say that paragraph is perhaps one way of looking at the nub of the invention, and in particular I placed emphasis on line 40 and the fact that the configuration, this is the distributed configuration, allows direct integration with existing call center applications. So it's really just that.
You say that's fundamentally inconsistent with the appellant's construction.
I say that's fundamentally inconsistent with the appellant's construction. I've been through the spec. I have noted down on my note what I've said in my, rather facetiously, as my 8 best points outside of the figure 14 embodiment. But really what I want to look at is perhaps, let's look at 4 of them. The figure 3, distributed arrangement. The figure 6, description, and that it's clear that it is envisaging both modes of routing. The portion of the specification about scaling, which makes clear that the system can not only be implemented in a distributed fashion on the call center infrastructure, but it can be routed through it. And finally, that paragraph we've just looked at in the overview.
If I've understood that sentence correctly, and I may not have done, but if I have, that is talking about functional integration. That's not talking about physical separation, is that right?
Yes, it's talking about functional. My understanding is there was a lot of discussion at trial about physically, if you had a call centre with a fence around it, if you put it in a shed on the call centre grounds, but in a completely different machine, that's implementation at the call centre, but not implementation within the call centre. My submission is this sort of discussion is not enormously helpful or necessary, because as we've looked through the spec, it has been made apparent that the call processor can be distributed, and the processing part of it that is going to implement features E, F, G and H can be placed within existing call centre infrastructure.
Yeah.
That's really the end
in a
of it.
functional sense.
In a functional sense,
That's the
yes.
critical point on your
Yes.
submission,
Yeah.
as I understand it. And it's nothing to do with physical.
It's nothing. No.
separation.
No. That's my run through the judgment. Sorry, but that's not. That's my run through the patent. I've got a note of the judgment. I may skip that because you've been taken through the judgment in some.
Speaking for myself, I think it would be helpful.
Oh well, I shall
If
do
at
it.
least, if at least briefly,
Yeah.
you can give us your submissions. We've heard very clearly from Mr. Silverleaf just before lunchtime of why the judge was wrong, and that it's been submitted that she misunderstood his submission, and therefore it would be helpful to have your answer.
Right. Just give me a moment. Right. So the judgment is tab 9 of the core bundle. The judge picks up the patent itself at paragraph 69 of her judgment. At so 69 and 70, she sets out the background and the aim of the patent. At 72, she notes the figure 3B embodiment, and she says that one's within a single unit. At 75, she introduces the two embodiments, which she does by reference to figure 12 and 14A, which is entirely correct. She notes their discussion in the quasi-consistory clauses and the fact that they're presented there as alternative arrangements. She's right, they are, and they're described as such, but actually one gets the flavour of how integral they are as two alternative ways of embodying the invention when one looks at the main part of the description. And then she sort of bookends that part of her judgment. So 75, she says there's two ways of doing it, the routing. 76 onwards, she discusses what they are, and 80, she then bookends that saying in both of those, the transaction information is processed in a particular way. And she says the difference turns on whether the transaction information is routed directly via an external entity without for processing, without being processed by the call centre. So she's spot on that. At 81, she notes the submission that it distinguishes between systems that are inside and outside. And she makes quite clear that that's not correct. The routing may be done not via the call centre in some instances of figure 12, but not necessarily all.
I think this is really at the heart of Mr. Silverleaf's submission. It's 81, possibly read with 82. Well, I think what he submits is that the judge has fundamentally misunderstood his submission, and that he was not making a submission about inside and outside the call centre. He says she seems to understand that as a physical separation.
Well, he puts it in his skeleton before this court as this idea of without going into the call centre processing environment. We've been through the patent in quite a lot of depth, and it never distinguishes between, when it talks about the call centre, it only distinguishes between two aspects of the call centre: agent accessible and not agent accessible. This idea of it going into the call centre but not into the call centre environment was something that the judge didn't follow as a distinction made by the patent, and I don't follow as a distinction. It's not a distinction made by the patent. And what the judge was trying to, in my understanding, get at is, well, you've said there's this distinction between it can go into the call centre but not within the call centre environment. Where do you draw the line between that? Because I don't find anything in the patent to help me on that. And that's where I understand you get that long passage of the transcript going, well, is it a locked room? Is it in a shed? Is there a firewall? All that sort of stuff. And the reason that the judge, I don't think, misunderstood what her finding was that there is a concept of physically inside, physically outside, but there is no concept between physically inside but outside of the call center environment logically, and where that, so that I believe is where the
forgive me, Mr. Davis,
yeah,
interrupting you. You may be right.
Yeah.
We'll have to think about that. But at the heart of your submissions, as I understand them, you've drawn a distinction between keeping information away from the agent,
yes,
and keeping information away from the call center as such. Do we see that distinction being made by the judge in explaining her reasoning?
I think the judge appreciated that the hosted payment gateway was outside of the call center, and I think one gets that when one looks, I think, at figure 11 and figure 12, because they actually move it outside, and part of the aspect of a hosted payment gateway is said to be physical separation as well. So she did understand that as a in my submission, as a feature of the figure 12 embodiment. But I don't, in my submission, it seems that the judge did not follow my learned friend's distinction between information that was inside the call center but not inside the call center environment, because that submission just doesn't hold water. So I don't believe that she, I would say that she didn't understand his argument. She understood his argument and rejected it.
Right. Thank you.
And there was a little bit of, if one reads through the transcript with the greatest respect to my learned friend, if he kicks me under the table, of, and I hesitate to accuse judges of doing this, a little bit of playing with the advocate of, well, how does that work, Mr. Silverleaf? Is it in this room? Is there a firewall? Is it in a shed? How's it done? So she understood all right.
Thank you.
Right. So that's how I say the judgment went. I then perhaps should pick up on paragraph.
Indeed, I think you've slightly done yourself a disservice,
Have I?
because in paragraph 82, I think she does recognise the distinction. It's the second sentence. She says, rather, as set out above, the discussion turns whether the sensitive information is sent to the external entity without going to the agent or the agent's system, or whether it's sent to the agent's system for processing, albeit without being divulged to the agent. And you say that's correct.
Yes, because in all of those, she says it's notable the examples to illustrate this distinction are all examples where the call process is located outside of the boundary.
Yeah, I noticed that she put quotation marks around the word boundary.
Yes.
And I don't want to speculate too much, but I did wonder whether that shows that the judge was not using boundary in a physical sense, but in a conceptual or functional sense.
I would. My submission would be that's entirely right. That's how I read it.
Yeah. And as my lord says to you, something in the middle of that paragraph does appear to capture precisely the point that you've been advancing to us today, which is that the essence of what this system was designed to achieve was to keep the relevant information away from the agent or the agent system.
Yes.
Not necessarily keep it away from the call centre.
Yes, absolutely, absolutely. I can't hide, I don't hide, that there is an embodiment which does that as well.
Yes.
But the claim 9 is broader than that.
Right.
The judge deals with the claim 9F integer from paragraph 107 of her judgment. At 108, she considers the main dispute, third line, claim 9, whether claim 9 requires the information to be isolated in the call processor and sent directly to the external entity without being transmitted through the equipment. I read that as twin, acknowledging firstly, it's got to be only in infrastructure outside of the call processor, and it's got to be rooted. Let's not quibble about the word directly, rooted, so that it doesn't go through that equipment in the call center. So she gets the twin aspects of the claim there. And at 112, she sets out, so at 111 she sets out my learned friend's contention and says there's two problems. Firstly, she says, the first is there's nothing in the patent to suggest that claims only cover the situation where the call processor or call processing system lies outside the boundary of the call center environment, to the exclusion of arrangements illustrated, for example, figures 2 and 5. I say, spot on, she's saying that a problem with the submission is that the claim covers this distributed function. It doesn't only cover ones that are outside the call center environment logically rather than physically. And then at 113, she looks at the second contention, which is the routing point, and whether or not it goes via or not. So she makes the two distinctions I've sought to make for this court, routing and distributed implementation, 112 and 113 of the judgment, exactly what I'm probably putting more eloquently that which I've been trying to get across. That's mostly it. I want to deal finally, I think, with a couple of points put by my learned friend, really picking up on two aspects of his skeleton. The first in paragraph 22 and the second in paragraph 27. And to some extent, they're slightly cheap points, so I'll make them quite quickly. In paragraph 22, what he says is that he says the following: the single construction issue arising on the appeal against the finding of invalidity is whether the claim, in particular 9F, requires the request generated from the transaction information signals to be sent to the external entity without first being sent to the call center's data processing environment. We say that's incorrect. There's two issues: it's distributed implementation as well as routing. The second point really is his point on the simple language of the claim, and the point taken at paragraph 27 of the skeleton is that 9F says via a data interface to an external entity. It does not say via a data interface to an application server within the call center for onward transmission to an external entity. doesn't need to. If it's ambivalent about routing, by not mentioning it, it gets across the fact that it's ambivalent. If it wanted to exclude that particular routing, the way it needed to draft the claim was to put the call centre's data processing environment in the claim language, or indeed even put the call centre in the claim language, and then say you were avoiding it. But of course the judge found that this claim doesn't need to be about a call centre or payment processing at all. It's broader than that. Right, just give me a moment. Yeah. Well, that's such a cheap point.
Certainly there's no need for cheap points in this.
Can I ask you a question?
Yes.
Integer 9F. Well, 9E requires generating a request.
Yeah.
And 9F requires transmitting the request. You've been addressing the linguistic point that 9F doesn't say how you transmit it.
Yeah.
It can go through the call center. What about 9E generating the request? Is that something the call processor has to do?
As I understand it, the way it was, this is not the best drafted claim in the world. The difficulty is claims come in two flavours, should come in two flavours according to the Patents Act. Method claims, process claims that describe doing things, and product claims that cover things you can...
Claim 1's a product and claim 9's a process.
Yes. Unfortunately, what one tends to do is one puts process distinguishing features in products, i.e. how the product works, and one puts product distinguishing features in processes. But then, of course, nothing needs to be implemented on hardware anymore, so the product distinguishing features are sort of modules. But something needs to do this processing of the claim.
Well, that's true, but the claim doesn't actually require a call processor.
No, it doesn't. It doesn't. But
let me cut to the chase. My point is, are you within claim 9? If, like 14C, you send the data to the call center application, it's called an application server, the application server generates the request.
I say yes. The way the judge interpreted the claim, which particularly in the inventive concept, which I don't believe has been challenged and was needed for all sorts of reasons, is that although it's a method claim, having had a first interface, second interface, and a data interface, there is a logical box, not a physical box, a logical box around the claim within which there is gubbins that does the processing. That can be distributed. So it could be partially outside the call center, and it could be partially on existing call center infrastructure. The specification then explains at 3B that there are 3 modules, and it's the first of those modules, the top one on 3B, that logically contains the receiving of the signals, the transmitting of the signals, the 2 telephone interfaces. And it's the final one at the bottom, the DPM, I think it is, that is doing this generating, transmitting, receiving, processing.
They don't need to be in the same physical
They don't
box.
need to be in the physical box. No, the description...
Figure 15 shows an example where they seem to be physically segregated.
That is probably so. Figure 15 shows an example in Yes, that's right. That's right. It has the telephony card 50, the telephony processing module 52, and then somewhere, hopefully, the DPN 54.
But to put the point you made a moment ago a different way, you can implement the entire method of Claim 9 entirely in software.
Yes.
You don't need any hardware at all.
Yes.
Except insofar as the software has to receive the voice and data signals.
Yeah.
And then to output them. But that's it.
Yes.
Provided you've got data input and data output, the rest of it could be in all software. And that's deliberate.
Yes.
That's entirely deliberate. That's why they sued you for infringement of Claim 9 and not Claim 1.
Indeed. Indeed. Was there a question within that?
No.
I hope I've responded to some of the points, but as I say, whilst it is a process claim, it needs a logical box. That logical box showing that it could just be software. But when we come and look at why I say it may not, on my little friend's interpretation, it may not matter. Sorry, I've lost my train of thought. Just skip that bit. Right.
Can I don't know if you'd finished generally on ground one.
Yes.
Can I ask you about what Mr. Silverleaf made submissions about just before 1 o'clock, which is the topic of what the court should do if you're wrong on the construction of Claim 9, and the contrast with the other systems that we've heard about, Schaeffer and the other one. Do you agree with him that, for example, there would be no need for this court to remit the matter?
I was intending to move on to those.
All right.
That's your respondent's notice.
It's our respondent's notice. We do say, we as may have been appreciated, we have difficulty, and it's clear from my skeleton, trying to work out exactly what is excluded. Because what my learned friend is running is, there is an exclusion in this claim. It excludes the figure 14 embodiment. Well, that sort of takes us nowhere. You can't construe a claim wandering around with a copy of figure 14 and decide whether or not the prior art falls within it or not. That was a convenient way of making the Van Valkenburg argument, but nonetheless, you don't construe a claim just saying, well, it excludes figure 14. You ought to be able to expound what it excludes. The judge, in my submission, also had some difficulties really pinning down the scope of the exclusion, which is why she labelled it as the isolation feature. But it hasn't really been put that way before the court. It's put various different ways. And depending on exactly what it means, the prior art is more or less effective. Where I've got to is the following. If my learned friend is right about one of routing and distributed implementation, but not both, the claim is still obvious over Van Valkenburg. If he's right about both, it isn't, not the way we advanced it at trial. Even if my learned friend's right about both routing and distributed implementation, the patent is still obvious over Schaeffer. And I can take you to why that is relatively briefly, and I'll try and do that. So let's start with Van Valkenburg. It is worth looking at the way this was run at trial. So one needs to dip in to the judgment. So that's tab 9 of the core bundle, and it's page 100. Sorry, paragraph 134, and the judge outlines how Van Valkenburg works, and then she sets out at paragraph 140 the 3 objections taken to obviousness. And what she says is this. She says the first objection taken to obviousness is the isolation feature, which she doesn't read into the claim, and that then falls away. The second was Van Valkenburg allowed voice communication to continue whilst data was being entered, and whether or not it blocked both voice and data. And she rejected that, and that's not appealed. And then the third objection was Van Valkenburg was sort of on all the time. It didn't have this switch between safe and active. And on the basis of the evidence, she said, well, it's obvious to have functionality you can switch on and off. So the second and third aren't pursued. The first is the isolation feature, as was sort of put at trial. At the top of the next page, the learned judge sets out what was said by Mr. Robinson to be an obvious way of implementing Van Valkenburg. And my understanding is that that, as a matter of fact, is not challenged and can't be challenged.
No, the argument is it doesn't fall within the claim.
Pardon?
The argument is it doesn't.
The argument is it doesn't fall within the claim. Now, my argument today is yes, it does. What I've asked my learned juniors to do is to blow up the diagram. Can I hand that up? Because
I'd be great for that, because I found it quite hard to read.
So did I. So for some reason, more than 2. Now, this has some text at the bottom of the diagram. My understanding is that came from the expert report, but perhaps I can just ask you to disregard that. Now, how do I get to the claimed subject matter? As I've submitted before, what the claim is about is drawing a sort of virtual box around things that carries out the process. So when one looks at what one has here, let's start again, let's go back a bit. It's customer telephone on the left. That's the user. The PSTN is the public service telephone network. And then there's this Valkenburg device, which is in red. The line that goes into the Valkenburg device on the left is the first telephone interface. And there's no argument, my understanding, on that. On the right, there is a line, an arrow that goes to the call center system, and that then gets passed on to the agent. That's where the voice goes, and that's the second telephone interface. Now, in the I get to the claimed subject matter. Let's talk first of all about the routing. Start again. Let's talk again about the distributed implementation. If distributed implementation is possible, I am allowed to draw a virtual box, including not only the Van Valkenburg device, but also the agent's PC. And all of that is within my call processor. And I then route directly via the internet to the IVR. So if I'm allowed distributed implementation, I still read straight on to Van Valkenburg. I just need to put the Van Valkenburg device and the agent's PC in the same box, and I'm still avoiding the agent. If I need just to talk about, so that's routing. If I can't have distributed implementation, but the route can still be via, then my Van Valkenburg device, the top of it becomes my data interface. I'm then within an isolated unit, just the red box, and my data interface goes via the agent's PC and then to the internet and then via the IVR. So if I'm sorry, it's not going via the IVR, it's going the agent's PC to the internet. So Van Valkenburg, if my learned friend's successful in convincing your lordships that it's implicit to the claim, both that routing not go anywhere near the call center infrastructure and implementation can't be on the call center infrastructure, then not obvious over Van Valkenburg. But if he's only partially successful, obvious for the reasons I've given.
That's very helpful.
Schaffer, as I believe, may take a little bit longer. And again, let's start off from the judgment. As the judge indicates, Schaffer is a conferencing system, but one that permits the selective blocking of particular media streams. And one sees in figure 2, effectively a box. And that box has 3 endpoints. And my understanding was the way it is obvious to implement this in a payment processing type environment, which would be an obvious thing to do, is your endpoint 70 is your user and your first telephone interface. Your endpoint 71 is your agent, and your endpoint 72 is something that's going to go to an external entity, and it can be switched so as to conduct the blocking and selective blocking of the claim. We get that from paragraph 156 of the judgment. Mr. Robinson explained the skill team would understand this to mean that DTMF signalling could be blocked from reaching a particular endpoint, such that it could be blocked from being transmitted to the agent without other media streams being interrupted. There were 2 reasons that the judge held, sorry, 2 reasons put before the judge as to why it would not be obvious. And we find those at paragraphs 161 and 162. 161 is the isolation feature, so that's the one we need to revisit. And the other one was that Schaffer does not suggest blocking of signalling whilst transmitting voice. And that was rejected as being as actually being Schaffer did disclose that, and it was, even if it didn't, it was an obvious thing to do, and that's not challenged. So again, we basically have, if my learned friend's right, would it be obvious to implement figure 2, turning back to page 134, separately as some sort of isolated aspect? So there's no real issue that what's shown in figure 2, this MCU as it is, could be considered to be the call processor of the claim, and it has the 3 endpoints as required by the claim. Now, Mr. Robinson discussed the functionality of the MCU, and to look at that we need to go to his first report, which is in the supplemental bundle, tab 12, page 266.
MCU is multi-point conference unit, isn't it?
Yes. Yes.
So which page are we now at?
Perhaps I could ask you to turn, first of all, to the supplemental bundle at page 260 of the bundle, just so we can orientate ourselves. And so this is my client's expert, Mr. Robinson, he starts considering the prior art at paragraph 124, page 260 of his report. We see that he talks about Schaffer. He then sets out the background of the invention, that's the Schaffer invention. The summary of the Schaffer invention is on page 261. And he talks about that at some length. And then on page 266, he discusses the skilled team's response to Schaffer. And perhaps I could ask you just to read paragraphs 152 and 153.
Yes, thank you.
So there he is describing Schaffer as a flexible system that could be used in a call center environment. There's not as much discussion there of nuts and bolts, of exactly how you would do it. But he has already talked about that when he was discussing the common general knowledge. And we find that a bit earlier on. So he says, at this point I've just taken to you, you could implement a flexible system in a call center environment. At page 252 of the bundle, that's turning back in his report, he talks about the systems used in call centers. So this is Mr. Robinson's discussion of the prior art. And what he says is, he discusses them starting at paragraph 37. But at paragraph 40, perhaps I could ask you just to read that paragraph. And what I get out of that is Mr. Robinson saying the way I would implement Schaffer would be the call center, but it's part of the common general knowledge that anything that you could implement at a call center, you could contract out to an independent third party such as Capita to be at a different premises and not as the customers, but the overall approach and design would be the same. So picking up the box in figure 2 that we see in the judgment and putting it separately as akin to a hosted payment gateway, accepted to be common general knowledge, would be an obvious way of implementing Schaffer. And my note, also from my note, he makes the same point effectively slightly further on in his report. So just to give you some context, the box in just below figure 2, the large box, the MCU 76.
Oh, right, the Schaffer.
Yeah, the Schaffer box. And Mr. Robinson makes essentially the same point when he discusses the teaching of the patent. He discusses the teaching of the patent from para 213 of his report, page 267 of the bundle. And when he's discussing figure 2 of the patent, he says the following: the description of figure 2, so he's talking about the patent here, states the call process can be made compatible with any traditional telephony network, including SIP and VoIP. And he goes through, he says the skilled person team would, and we have A, B. And if I could just ask you just to read C. And I read him as saying there, provided you're not messing with the same, the system and the functionality, the skilled person would know as part of your common general knowledge that you can place a box at any part and it can be outside. So we say on that, even on my learned friend's construction, it would be obvious to implement Shaffer, let's use his expression, effectively as a hosted payment gateway. Take it outside the call center and put it separately. So that is how we get to the findings of obviousness. Unless I can assist your lordships further.
Thank you. I'm going to check if my lords have any questions. Yeah. Thank you very much. Yes, Mr. Silver.
Tidy myself up. I'll take the points in the order my learned friend dealt with them. This is not necessarily the order of importance. He referred you to some law, starting with Sir Christopher Floyd and Philip Morris. I don't dispute the law at all. The question is what the claim means in any particular context. The law doesn't affect that, and it therefore doesn't affect either my submission or in my submission of the case. The Manual of Patent Office Practice right at the end makes it clear that some embodiments may be inside the claim, some may be out. It says you should only take an objection where that causes a problem. The claim should be clear, so embodiments can be outside. Again, it's entirely consistent with my submission. He took you through the specification, considerable length, very helpfully. In my respectful submission, nothing he said impacts the arguments I presented to you. The core point is this. As I explained to you in opening, the way that the claim achieves avoiding the information reaching the agent is to send it not to the call centre, but to the external entity. If you don't do that, you cover systems in which the only way the agent of seeing the information is avoided is provided by something that is not part of the claim. Everybody agrees that the core purpose of the claim is to stop information getting to the call centre agent. To interpret the claim in a way which results in it not achieving that objective, and that objective is only achieved by external features in the configuration of the call centre, cannot, in my submission, be right. It's an absolutely classic example of a nonsensical interpretation of the words. There's a very straightforward interpretation of the words, which allows you to reach the answer that the claim does achieve the objective that everybody agrees it's supposed to achieve, namely avoiding the information going to the call centre agent. And that is to interpret 9F as requiring the information to be sent via the data interface to the external entity without going to the call centre. My learned friend's submissions don't deal, while we're on that, my learned friend's submissions don't deal effectively with the requirement that the call processor generates the request which goes out. My learned friend's Sorry, I'm a bit puzzled by that. Where is the call processor in Claim 9?
The call processing system, sorry.
Where is the call processing system?
It's a method of carrying out or processing calls.
Indeed.
The judge has held that the claim requires some form of call processing system.
paragraph 70, I'll give you a wrong. Paragraph 96 and 97 of the judgment. That's not challenged by either side. And we say she was right. You have to have a call processing system to carry out the functions of the claim. It can be implemented in software, and it can be implemented in distributed software. But my learned friend's arguments rely upon asserting that some of that distributed software can be at the call centre. I'll take you very quickly to the passages in the specification that relies upon it. Actually, when one reads them, one can see that they are not concerned with integrating with the call centre, as he suggests, but are just ways in which you may implement the methodology of the claim. But what his arguments don't engage with is that this claim is clearly designed to be limited to a system in which the system takes the necessary information to generate the request to go to the external entity and sends it to the external entity, features 9E and 9F. A system which simply transmits the information to the call centre for that process to be carried out doesn't comply with feature 9E. This is why I say it's the combination of D, E and F that takes you to the result. My learned friend points to the fact that for a payment authorization, you need information from the call centre as well as information from the caller. And he says the claim doesn't include a requirement for that, so it must be wider than we say. We respectfully submit he's wrong. The claim, we agree that you have to have that information. But of course, this claim is apt to read onto verification requests, for which you do not need information from the call centre. And the fact that it doesn't require information from the call centre doesn't mean it can't use information from the call centre. His submission is a classical example of the logical fallacy of the undistributed middle. This claim covers operations in which there is information provided by the call centre as well as the caller. It just doesn't require that information be provided by the call centre, because it also covers operations in which information is not required from the call centre. So the fact that transaction information signals may be broader than payment information is neither here nor there, and the fact that the claim doesn't have a requirement for information to come from the call centre is neither here nor there. The claim, therefore, because the claim requires the request to be generated by the call processing system, in my submission, when it's applied to a payment authorization request, it implicitly includes the transmission of information from the call centre to the processing system, because the processing system needs that information to generate the request. Now, the breadth of the information, it doesn't matter what the sensitive information is, you want to keep it away from the agent. Everybody agrees about that, because it can be used for fraud, whether it's dates of birth, addresses, or things that can be used for identity fraud. You want them away from the agent just as much as you do everything else. So the fact that transaction information signals may be broader than payment makes no difference to the construction of claim 9. If figure 14 is within the claim, you still have the result that the information is kept away from the agent, not by the features of the claim, but only if you configure the call centre appropriately to achieve that. So again, even if the transaction information signals are considerably broader than mere payment information, the problem with including figure 14 within the claim is exactly the same. My learned friend says figure 14 achieves the objectives of the claim. 14A and B do, 14C doesn't. That tells you that it's not the features of the claim that are achieving the objective. There must, in my submission, be something wrong with the construction of the claim, which on its face includes embodiments which don't achieve the desired objective.
So, does that mean you're accepting that 14A and B are within?
No. 14 is excluded.
But you say they nevertheless achieve the objectives of the
No. They don't. Not because of the claim features. Remember, the claim doesn't have to cover everything that's described. What is described will achieve the core objective that everybody's aiming at, keeping the information away from the agent. But the way the claim has been crafted, the method that is used in the claim to keep the information away from the agent is to divert the sensitive information and send it to the external entity. None of Figure 14 do that. Therefore, they're all outside the claim. The fact that Figures 14a and 14b, because of the way the call centre is configured, achieve the desired objective is neither here nor there. It doesn't mean they're within the claim. The judge, turning to what the judge was doing, and passing over my learned friend's suggestion that my construction is flopping about and has different ways of dealing with different problems. My construction, in my respectful submission, is entirely coherent, and the judge was making exactly the right distinction in paragraphs 80 and 82 of the judgment. And that is the distinction that my construction makes. The problem that arose with my submissions to the judgment is the judge didn't appear to understand that that is what I was submitting. My learned friend points to Figure 15. Figure 15, on the text of the patent, is specifically directed to the Figure 14 embodiment. See page 30, lines 36 and 737, and the following sentence. It would look different if you applied it to the embodiments in which the information is not sent to the call centre. And this brings me to my learned friend's distributed functionality point. Now, he points to text at page 20, lines 11 to 16. And says that allows you to integrate, distribute and integrate with the call centre. With a great respect to my learned friend, that is not what this text says. What it's talking about is that you can implement the call processor on a computer, an application server. And that application server may be located physically at the call centre premises, as in Figure 2. The telephony card and the processing functionality, TPM and DPM, may be in the application server. And if you're using an application server, so basically it's saying you can use a general purpose computer with the appropriate cards installed. And then it goes on to say that if you're using an application server that's at your premises, you can use it to handle other transaction-related applications: purchase, management, transaction logging, maintenance of transaction database, and the like. Those are not call center functions. Functionally, that server is not operating within the call center environment. They're general accounting or reporting functions. The passage is not addressing where the payment processing takes place, where a request is generated, or where it is sent from the data interface of the call processor. It is not concerned directly with whether the computer is being used, which is being used as the application server, is isolated from other call center systems. In the embodiment covered by the claim, that will be the case. In the integrated embodiment, which is outside the granted claims, you can have an application server which is part of the call center's operations. So this passage doesn't assist my learned friend at all, in my respectful submission. It's completely and utterly neutral, and if anything, is directed specifically to the embodiment in which the Figure 2, an embodiment in which the call processor is physically located at the call center, but is functionally isolated from it to give you the extra benefit of acting as effectively as a hosted payment gateway. I think the only other thing, unless you have specific questions for me, the only other thing I want to deal with is my learned friend's suggestion that I have to succeed on two aspects routing and isolation. In my respectful submission, what he's trying to do is create two features out of one. What I say the claim means is you send the request from the call processor to the external entity, not via the call center. It's one single requirement, and dividing it into two doesn't help. So, turning to Van Valkenburg and Schaffer, if I've understood my learned friend's submissions correctly, he accepts that if I'm right as to the meaning of the claim, Van Valkenburg does not render it obvious. He says that Schaffer renders it obvious, but the problem he has with that is that Mr. Robinson, in the evidence he refers to, is not addressing the relevant question. He's not considering where the functionality is in relation to the call center. His point about outsourcing is you outsource your call center to Capita. They're an IT services provider. There's nothing in that evidence. And when you look at the earlier bit of the evidence he showed you about the structure of a call center, he said you can do this through Capita, i.e. Capita will do it for you, but it's otherwise basically the same. That is exactly right. You've just moved the call center to be a function provided for you by Capita. So that doesn't help. That doesn't teach you any additional technical or approach or processing approach features. There is nothing in that evidence that suggests taking this particular functionality, separating it from the call center, and thereby creating a system in which the call center doesn't receive the data at all, with the dual benefit that your PCI DSS compliance requirements are outsourced to the call processor, and the call center agent doesn't receive the information. It's no more obvious over Schaffer than it is over Valkenburg. I did not understand my learned friend to say that you could implement this thing piecemeal in a way that would achieve, Schaffer piecemeal in a way that would achieve the requirements of the claim, and he was right not to do so because you can't. There is nothing in Schaffer which would lead to the idea of making the call processing system functionally separate from the call center. Nothing he said to you about Schaffer leads to that conclusion. So I'm well under time, I'm pleased to say. For those reasons, we say our construction of the claim is right. Once it's accepted our construction of the claim is right, it's accepted that Van Valkenburg doesn't invalidate. And the arguments advanced in relation to Schaffer fail to address the fact that Schaffer does not discuss what happens to the information or functional isolation from the call center. Schaffer's all about being a multi-point processing center. In other words, it is a call center. So it just doesn't address the right question. Unless you have any questions, those are
check if my lords have any questions.
How do you want to proceed now?
We will rise now. Please stay in court. We intend to come back in a few minutes. We're going to consider the next steps.
We know that doesn't mean
That's what's going to be. It won't work.
give us a judgment.
Is that how it works? So left.
You don't need to. 99%.
It is really. You don't know where we can go.
Years ago.
Yeah, he took a room.
Somewhere in the middle, there's a pocket. Get a pair of secateurs and just cut it. Somewhere.
You know my right. Olivia.
They haven't got to.
That's always one for them.
That's right. I think if anyone's what's that fact? That very powerful. Can't take it.
So you realise
Silverleaf, Mr. Davis, we do not accept ground one, and in the light of that conclusion, we don't think that it's going to be necessary to hear the other grounds. Subject to anything that Council may wish to say to us in a moment, what we will therefore do is not sit tomorrow. We will reserve our judgments, and they will be circulated in the usual way on a confidential basis. And I know that those who are familiar with the legal system know that that's an opportunity only to correct typographical and other obvious factual errors. It's not an opportunity to argue the case again. And in particular, I have to stress, as this court has done in recent judgments, that the draft must be kept confidential at that stage, and any breach of that embargo is taken very seriously by the court and may, in fact, amount to a contempt of court. May I check if there's anything else that anyone wishes to raise at this stage?
I can't think of it.
I have a moment.
I can't think of it.
Very good.
The confidentiality of the judgment, can I just check, can it go to those in my client who instruct as well as solicitors?
Well, normal form these days is that parties provide a distribution list in advance.
So you'd
in
like
our
a
I believe we have had a distribution.
You've had a distribution.
Yes, thank you.
May I have a moment? So there's no point, yeah. Right. My lords, particularly Lord Justice Arnold may recall that the costs awarded to my client at trial on an interim basis have been held in escrow pending determination of this appeal, so it's not to be paid out. Since your lordships have indicated that you intend to dismiss the appeal, can I ask now that that escrow is released so that those can be paid out? Obviously, we will address you further on costs of the appeal at a later stage.
I don't think I can resist that.
Very good.
Yeah, we'll make an order to that effect. Can you draw that up and agree it for me to approve as soon as possible?
Yes, my lord.
Is there anything else? Thank you. Before I conclude, can I offer our sincere thanks not only to the advocates from whom we heard, but from the advocates from whom we would have liked to hear. There will be other occasions, I'm sure, for them, and also to everyone who has assisted in the preparation of this case. Thank you very much.
Just occurs to me, suddenly popped into my mind, although we're not going to hear argument tomorrow, you might want a 3122 order in respect of the confidential information, because the scales and arguments have been referred to in open court, even though the relevant bits have not been referred
I'm
to.
obliged for the reminder. Can I apply
Yes.
for 31?
Yes.
I presume that's not resisted.
Yes. Yes. Can you include that in the draft order that you're going to send for my approval?
Yes.
Thank you very much.
Very good.